Everybody, it is
I didn't hear you bang.
Monday, November 9th, 9 a.m. We're at a regular Commissioners Court meeting. So everyone knows Judge Kelly has another commitment, which is actually in our office, in his office right now, so I'll be presiding, but if we do need him for something, he can break away for a few minutes. Get started. Commissioner Harris, then you have the prayer and pledge.
Lord, you're the builder of all things. Please guide us in this meeting. Help us come up with effective strategies that can enable us to move forward as a team in a meaningful way. Help us generate good plans that are practical, sustainable, and easily implemented. Guide us towards the best way to take action to accomplish our goals. Help us to tackle all the topics we need to discuss. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I think everyone will notice that we have a little bit different setup today, and that is due to there have been some cases of exposure of COVID in the courthouse, and as a result of that, we are distancing and limited access to the courtroom more than we have in the past weeks and months. There is a live broadcast that's upstairs in which courtroom, Sheriff?
The main courtroom.
In the main courtroom upstairs, there is a monitor up there, so anyone that wants to, who came and wants to watch the meeting, it is available up there. And we will be allowing people to come in one by one based on agenda items and speakers and things of that nature. Public input. The judge usually uses his phone, but I think he would let us know if it is. So if anyone does, why don't you get his phone? Go ahead and call his number.
792-6161.
792-6161 if you have any public comment, and we'll if you call a little bit late, we will take that public comment at that time because we're a little bit different setup this morning.
Jonathan suggests, make sure that Debbie can hear everybody because she's doing court reporting. Can you hear us, Debbie? We can't hear her.
I don't, unless you had her on a screen somewhere.
Yeah.
To nod her head.
Hopefully,
Well, since she's doing the court reporting, she's going to have to make sure that she can hear us.
I think we're gonna see if she's on the screen over here.
She's doing it on YouTube.
she's doing it off YouTube.
Okay.
Oh,
And
okay.
Bruce, can you check to make sure that with the microphone setup that we have adequate?
Yeah.
They can hear.
You can see the.
Yeah, make sure she can hear.
Okay. If she's on YouTube, she'll be able to hear it like
Okay.
everybody else. Okay.
Test.
Test.
I would think that microphone location would pick up the way we're spread out.
He
pretty good.
can tell real quick if it's picking up, and he said it is.
Okay. Good. All right. Commissioners' comments. Commissioner one.
I don't have a lot to say. A little bit of rain this morning. A little over
You
the
didn't
weekend.
get any rain.
We did.
Oh, come on.
Tiny bit.
Moisture.
Number two.
During the election, the alcoholic beverage sale in precinct 2 passed, which is good news, fantastic news, as a matter of fact. And the important thing is, it goes into effect, people can start selling alcoholic beverages as soon as it's canvassed by the court, correct, County
That's
Attorney?
correct.
Right. So as soon as it's canvassed by the court, which, do we have a date for that?
16.
I don't know.
Next Monday, I would think.
I think so.
Usually it's within 1
So
week.
anyway, if establishments have their liquor license, they can start selling alcoholic beverages in precinct 2 at that time. The other thing is, I think it's important to remember that when the burn ban is on and the sheriff is here, it's a fine, what, $500?
I don't get into the amount, but it is a fine. I think it's up to $5.
Up to $500 fine for people that violate the burn ban. And we've had several fires in in precinct 2 recently, even though the burn ban was on. So, and you're liable, and, you know, the sheriff can cite you if in fact you're burning during the burn ban. So just make sure everybody is aware of that. That's all.
And really, to be as bad as it is lately with the fire dangers that we're having, it's not just precinct 2, we had them in precinct 4, we had a number of fires everywhere. We're pretty well gonna have to take a zero tolerance on it and start writing citations for those violations instead of warnings.
Right.
Because it's out there and we're just way too dry, it's getting way too dangerous.
Good deal, thanks. Okay, that's all I have.
I don't have anything, Commissioner.
Ingram volleyball girls, still #1 in state, 29-0. I think their next game is with Goliad, which is another tough team. Of course, they're getting down to where they're all tough teams, but the girls are rolling, and that's kind of exciting. We don't get that all the time. So,
Okay. Good news.
Commissioner Litz, there is no one who called in for public comment.
Okay, thank you.
You're welcome.
We'll go to the consideration agenda. Item 1.1, consider, discuss, and take appropriate action regarding the 2021 Kerr County resolution in support of the grant application for the Indigent Defense Formula Grant Program offered by the Texas Indigent Defense Commission, and authorize county judge to sign said resolution. Callie.
Hi there. Good morning. So
speak up.
Okay, yeah, absolutely. So this is for the Texas Indigent Defense Commission. This is the formula grant for indigent defense programs. We're looking to get about $57,000 to $60,000 in that range, but we won't know until we actually get the grant award, and we apply for this grant about every year. So.
How does this work with the PDO, the Public Defender's Office grant?
It's a different grant that is specifically that grant is more of an improvement grant. It's a multi-year grant. This grant is a single year grant, and it goes from year to year, and this is a smaller grant.
But it's for the same purposes, for providing defense attorneys to indigent?
Yes.
Yeah, we're switching programs this year, so we're gonna have 2 different reports. We're gonna have the single year, and then as we get the PDO office set up, then we'll get money for that reimbursement.
So do you take this money? How does that money?
There will still be attorneys who are appointed to represent indigent defendants, and so they'll still need to use that grant to cover those costs during this transition period.
This sounds like
Okay, during the
something
transition. During the
that-
transition.
Yeah.
And there will be some costs after the public defender's office is here for people who have conflicts, co-defendants and things
Okay.
like that.
Got one more question. What's our downside?
There is none. We've done this for about 15 years. It's just a formula grant, so they give us a percentage of all indigent cases that we appoint.
Okay, all right, thanks.
So for 15 years, every year, we have some kind of interim grant?
No, we've always been doing it under appointed services. We haven't never had a PDO office before, so we'll spend about $750,000 on appointed cases, and
Okay.
depending on how much their budget is, they allot us, 10% refund. So, better than nothing.
And we'll continue to have, will we be able to continue to apply for this grant in the future, even with the Regional Public Defender Office?
Yes.
Because we will continue to have outside need for indigent defense.
Correct.
Yeah, it's not gonna go down.
Right.
Right.
I move for approval.
Second.
A motion from Commissioner Harris, second Commissioner Moser, to approve the Kerr County resolution in support of the grant application for the indigent defense formula grant. Any further discussion? All in favor, say aye, raise your hand.
Aye.
Unanimous, 4-0.
Thanks, Cal.
Thank you.
Jennifer out there.
Item 1.2 is consider, discuss, take appropriate action to review, clarify, or modify COVID employee sick leave hour allotment for previous quarter. I probably wrote this agenda item instead of actually Jennifer, and it's really not previous court orders, but previous federal rules that we agreed to comply with. I put it on the agenda along with Jennifer because, as we all know, there's been a little bit of an outbreak of COVID in the courthouse. And one of the reasons that I think that we had it is that we have employees coming to work when they're think they have allergies or something, you know, they have a minor ailment that turns out to be COVID. And the reason is these employees don't want to necessarily use their sick time up for a minor headache or something along that line, a lot of different things. So I just want to put it on the agenda so we can give some guidance to HR as to how we move forward with this to make sure that our employees are staying home when they're sick, and also that they're not using their normal sick leave because of the current COVID situation.
Correct. Currently, we have, as of the end of last pay period, we have about 6 employees who have already gone over the 80. Some of them, you could say substantially. I know Kendall County, I've talked with their HR director, and they have given another 80 hours on the county because of the same situation. So it would be my recommendation to give an additional 80 on top of
Wait,
this.
say it all again, Jennifer, I'm not following.
On top, we were given
What is the recommendation?
my recommendation is that the county authorizes another 80 hours of COVID sick time
80.
That's a month of sick time.
for those who need it.
And need is defined by this 6-point criteria here?
Correct. If you feel any symptoms whatsoever, like Commissioner Butts said, that we've had people that just think it's allergies and they come to work. So any symptoms at all, this will help people stay home.
So that self-diagnose if they've got symptoms. Is that true?
If they have a symptom, then they need to contact their physician.
But
Yes.
it says in number 3, if they're experiencing symptoms. Number 2 says they have to have healthcare providers say they've got it.
Right, if you fall under any of these criteria.
So
you
if
can
they
use
say
COVID sick.
that in themselves, they think they've got symptoms, then that's sufficient.
If you feel you have symptoms, then you need to contact your physician. But
But-
we don't want anybody coming to work with symptoms.
I understand,
So-
Jennifer, but this says if they determine themselves on number 3 that that's sufficient, they don't have to see a health provider.
Well,
Well, if you
I
feel
think it
sick,
would
you
be
can.
responsible to see a health provider.
To give
I'm
you,
just,
I
I'm
know,
reading it
but-
like a
but
lawyer,
that's-
okay?
That's what it says. That's what
It's what it says. It's
Right.
so they don't have to see a health provider.
They would be
just have to
eligible.
say, I think I've got the symptoms, and they're given sick leave.
Correct.
Okay, I'm just trying to,
Yeah.
and this is mandated by the federal government.
Yes, sir.
Part of it is.
Well, what
We're
part is
already
not?
doing it. She's asking for more.
Right.
And that's not mandated.
Right.
80 hours is not mandated.
The first
This
80 hours
criteria
is
is
mandated.
suggested.
The first,
And, there are a lot of places where you come in and they take your temperature. That's it. That's a real simple way to do it, and that would probably fix the issue.
But it doesn't, temperature is not
correct.
does not mean anything.
It's supposed to be an indicator.
We've
It's
had,
supposed to be an indicator. It is not an indicator. I can tell you from personal
right,
experience.
we've had
I've
several
never had
cases that have tested positive and said that they never ran a temperature.
So,
All they've
Well,
ever,
some people are entirely asymptomatic.
Correct.
so-
right.
but other people
But
have
that
tested.
is one of the things that's used in many
Right,
places.
exactly.
They just take your temperature when you come in. If you don't have a temperature, you go in.
Right.
but if I can speak, because we've dealt with it out there. The 2 different issues that Jennifer has, that my employees have brought up, is number 1, if I feel symptoms today, okay? What we're telling them, depending on what those symptoms are, then you need to go get tested. Right? They go get tested and it's negative. So then they come back to work. Right? Is that interim time from the time they first got the symptoms to the time they got tested and it was negative, can they count that as COVID, or does it go back to regular sick leave?
COVID.
All right? And that's why I'm saying COVID. So I think on Commissioner Mosier's deal, if they have those symptoms, they ought to be told that they need to go get tested too for it to count. If they just say, I feel sick for this week, I'm not going to go in and you're going to pay me COVID, I'm not necessarily, I agree with that.
I'm just reading what it says.
I know, I'm just saying there's no. Now, the other issue is, and why I think the extra 80 hours is good, what happens is normally they've already been out a few days before they get tested. And when they get tested, then the hospital, whoever's testing them, says they have to quarantine for a minimum of 10 days from that day they got the results. Okay, from the day they were tested, or if they still have a few symptoms, 14 days. So you're talking 14 days, you know, the 80 hours is only 10, really, all right? 14 days from the time they get the results. So they could easily be out 3 weeks up to the month, Commissioner, you know, with it before
Well,
they're
I'm
clear to come
concerned
back.
with your children and your spouse too, so those two things are in number 5 here. So that actually could carry, you know how it happens, somebody gets sick, you tag team each other the next.
Well, I
week.
had one employee that has a single parent daughter, okay, grown daughter, single parent. That grown daughter got it, and now she had little kids in the house. So my employee, even though she was healthy and everything, had to go live with her, the COVID one, to help take care of those kids while she got over it. So now she's quarantined too. Right? And, you know, even though she didn't have it, she intentionally had to go move in with them to help take care of the kids. So that should be.
You can easily, and then the problem even gets worse if, when this has happened, people are told because they were exposed, they're told to go self-quarantine, and they may be going through the second time.
Right.
They maybe have already been quarantined one time, and now they're being quarantined again. I think we need to increase the hours, and I think there's a certain amount of, you know, the employees need to talk to their supervisors, and I think I agree with the sheriff, they need to get tested. I think we need to increase the hours. The main thing is that we don't want our employees coming into the office when they're sick right now, because we just don't want to spread it.
Right.
And-
But I think one thing in here, testing is not a word in here.
Well,
And that, let me finish. And it doesn't, and you've said testing, you've said testing, you've said testing. So why don't we say testing is required, okay?
Well, we can't force anybody to be tested.
But we
I'm
can
telling
also
people-
not pay them.
What I'm asking
You
people
can
to
force them to
do
stay home and you can't force them to
is
get
they
tested.
need to contact their
Well,
physician.
how are we gonna know they have it if they hadn't had a test?
okay, let me interrupt my case when I had it, all right? And what they said I had. My wife was tested positive, had it, right? So she's quarantined. When I called them the next day, you know, because I started showing symptoms, can I get tested? They said, no, you cannot, because you automatically are presumed to have it because you're in the same house, you're also quarantined. Now, my sick leave didn't matter, but, you know, because I'm an elected official, but if I had, and I had another employee that had that exact same situation. They had direct exposure
I see.
with a person that wasn't even part of their house, but it was direct exposure and that person tested positive.
Yeah, but that
So they
count is the same thing
they
anyway.
required them to stay home, even though that wasn't in the house, for the 14 days. So you can't require them to get tested, but, so it's a
Okay.
Well,
catch-22.
Because they may not be able to get,
The,
yeah.
the,
Right.
the sheriff's accurate based on Peterson Hospital policy.
Right.
Anybody can go to Vernon and get tested at any time.
And it
But
happens.
I don't think we can require our employees to go to Vernon to get tested. But I'm saying that anyone that wants to get tested can get tested. Peterson may not test you.
Right.
But the other thing I'm hearing from Peterson Urgent Care is that they recommend that you wait 5 to 6 days. 6
Right.
days. They said 6 days from the last exposure to get tested.
Right.
Because if you go that day, which we've had a lot of people do, it comes back negative, but
Right.
another 6 days, it can be positive.
I think the supervisors just have to stay in touch with their employees, and between them and Dawn, figure it out, get it. Ms.
But
Doss,
the
generally
real
get it set right.
issue here is to let HR and treasurer know and auditor that if we're going to give, that they can continue to code employees COVID sick, which is a different code that we've set up, beyond the 80 hours. And we, according to the auditor, we're turning in most of these hours to the federal government for reimbursement. We're not sure how that'll all work out in the final
Right.
thing, but that's what the current plan is. So, but to play it safe, I think we do need to increase the, our COVID sick by 80 hours.
Do we have to be under emergency declaration for this? I think the answer is no.
We're
Okay.
under the
And
government.
one other
Right.
question, if I may. This is according to the Families First Coronavirus Relief Act. So, do we know how long that act is?
Through the end of the year.
To the end of the
12/31.
year.
Yes.
Okay, answered that.
Yeah.
So my only concern is it would take an act of Congress then to do something like for the flu next year.
Right.
Okay,
Right.
all right, thank you.
Well, and I do have another, I had an inquiry from an employee, and maybe this isn't the agenda item to put this under, but if you're at home, tested positive for COVID, you're using COVID sick time, but you are working, you're able to work from home. I believe that, it's the FLSA laws that if you're working, you code it as worked. So if you work 4 hours a day, you code it as regular 4 hours worked.
good.
And 4 hours that you don't, then you code it COVID sick.
Okay.
Because I've had inquiries about, about
Wait a minute, you
people
can be
being-
sick half a day? Is that what you're saying?
if you're working, if you're home sick using COVID sick, but you are able to work, then you shouldn't be charging all 8 to COVID sick.
Right.
If you are working, you need to code it as time worked.
Right,
regular
you're
time
able to
worked.
work, you shouldn't be getting sick pay.
Well, what we,
That's what you just
Well,
said.
you're-
what this
but you're-
You're saying I'm gonna be
You-
sick half
if you-
until
if you
lunch,
came
and
to-
then after lunch I'm gonna work.
Right, but if you came to work, you give it to everybody else. If you're,
I get it, but if I can work, I can work. If I can't work, I can't
well, let
work.
me explain how that happened.
You're talking about somebody who's
The one
basically
is probably my
quarantined.
employee.
Well, let me finish. You're talking about somebody that's quarantined at home.
They've tested
but-
positive.
And feels fine, and they're working from home.
and they've tested positive, and they're able to work from
And
home.
which category to put them under for pay?
If they're
Regular
working,
pay or?
right, if they're
COVID pay?
working,
Or to split it?
the hours that they're working, it should be coded as regular work. The times that they're not working, it should be COVID sick.
Why would they be working 4 hours? Why didn't you use that?
Ask the department head or elected official.
I had
because
an
that's what
employee
they've
that
been-
had the same exact thing, so that employee was able to take a laptop computer, and we got IT to help us get it hooked up to where she could actually do a lot of their duties on that computer at home while they were in quarantine. So the hours that they were actually doing those duties on that computer, then yes, I agree, that should be regular pay.
Right.
But the hours that they weren't out of the rest of the day, maybe they only decided to do 4 hours worth of duties. They're in quarantine, I can't force them to come in. So if they did 4 hours worth of duty, that goes on their timesheet as 4 hours worked. The other 4 hours goes on their timesheet as 4 hour COVID sick, because they can't come in. And they're doing what they can, because not their entire duties aren't totally 8 hours on a laptop.
Right.
They're different, but they can do the laptop.
But they're using up that time you're talking about.
Well,
So that could work against the employee ultimately.
Right, and the same goes like if you're on vacation. And, if you're scheduled on a vacation day, but something drastic happens and you have to put in some time at work, we don't expect you to code 8 hours of vacation. If you worked, you need to code the time as worked.
Well, it's not likely to happen, but you have somebody that has to be quarantined, they feel fine, they work from home, they're using their COVID pack. Then, they have a car wreck, they break their leg, now they gotta be out of work, and they've used up and they're exposed to COVID from EMT worker, or whatever. And now you just complicate things. I think you just pay them, one or the other. And
Okay.
split the
Well,
days,
there's-
because you're not gonna make it exact every time. You're gonna have an hour and a half of this, then I clocked in later and it was an hour and a half of
Commissioner,
that.
we're doing that right now. We're doing exactly what Jennifer says right now.
I think
every
it's
report.
complicated, it's overly complicated.
But that's what we're doing. We've always done it that way. There's no reason if someone works part of a day, they should be
But
coded.
you're
accordingly.
adding the COVID thing to it.
And if you're non-exempt, you have to.
No, it's
you have
not,
to-
COVID doesn't mean you just added a different code. Yeah, instead of just, vacation and work, you're vacation, work, and COVID. I mean, you're
It's
just adding a
just a code
second.
in the computer, Commissioner.
Yeah. it's just
I understand that, it's a code in the computer, you're adding a third code in there, or fourth or fifth, or
No.
whatever we're up to.
You already have a regular work code. That's
Right.
what you're doing. You're coding 4 hours as regular work.
Right.
You're coding 4 hours as COVID sick. It's not adding another code in there. Those codes are there. You're just using different one for the different hours of the day.
So what's the advantage for the employee?
With
Not
regards
to be used
to.
as sick leave.
And I think it's the advantage for the county, in part because, for example, we have one employee who is hard to replace that employee's services. And so in order to take
Get up
care
there
of,
so Debbie can hear you.
in order to take care of the people that she serves or he serves, they put in 2 hours. Like if one of my employees got sick and they put in 2 hours and said, that's really all I can do today. I'm not feeling well, I feel dizzy,
Sure.
but I've got to take care of X, Y, and Z
One thing,
because we
right.
each have separate duties in our office. And say one of my legal assistants was out, but we needed plea paperwork. She could get in, do her plea paperwork for an hour, and if she felt bad and needed to go put herself to bed, then I would say, okay, we're paying you for the hour, but the rest of the 7 hours, you get COVID sick.
That part I understand. The part I'm trying to get to is to get Jennifer to tell us what the advantage is to the county, to the employee. Is the advantage that at the end, when we have all this COVID pay, that we get some kind of government reimbursement or something? Or is this simply to allow that person to get paid 8 hours when they work 2 hours? Which is that?
It's,
Well, we shouldn't be trying to get federal money or reimbursements for federal money for time that's been worked. If you're truly
I'm not
sick.
talking about the time we've been working, I'm talking about any COVID reimbursement stuff. We've gotten a lot of money because of COVID in this
Right, and I
county.
think we've exhausted the money, the amount that we're
So
gonna
this,
get back.
this won't, there's no benefit in that category.
I don't.
there may be.
That's what I
We're
want, that's what I'm
keeping
trying to
track
get
of
to.
it that way. That's how we keep track of it, whether we get reimbursed for all of it, we don't know.
So in the event that we are gonna find a reimbursement, or that there is one offered, we'd have all that. So then, see, there's a good reason to keep track of it.
Right.
But what you were describing earlier doesn't strike me as a good reason to do it.
Okay.
Just because I felt good for
Well,
part of the day,
but-
not for the other part of the
But
day.
you agree we need to do it.
Right.
I agree you should keep track of it, yes.
Well, Harley, I think, well, Johnson's a good example. He came down with it, and he was still on the phones,
Right.
emailed, handling
Yeah,
business,
right.
but not coming in. You and I would do the same thing.
Sure.
You know, the phones are still gonna ring, and if you're physically able to do that, you're at least gonna get back with people and do what we can.
Right.
Whether we have the common cold or type A flu or this COVID deal.
Right.
Right. Well, we want them to be protected. I'm just
Right.
trying to figure out why, instead of it being sick pay, that it has to be in the COVID
Well, here,
category.
I'll give you a case I just thought of.
Okay.
Somebody's at home quarantined, they can't be here.
The auditor needs to make
Yeah.
one statement.
I just
We
want
got
to
too many people
clarify.
I'm talking,
Oh,
if it's
sorry.
okay. Thank you. The case would be if somebody's quarantined at home, okay, and they feel fine, and they have 4 hours of work that they can do, okay, and that's all, you know, just because that's a requirement for them to do, and they're finished, okay? They could keep working, but they don't have this task.
Yeah.
So, but they have to be quarantined, so therefore, there's a case, maybe 4 hours regular work and 4 hours of COVID related.
That makes
Yes.
sense.
Yeah.
Sure.
Yeah, okay. Sorry.
You were gonna tell us about the grant?
Yes, sorry about that. Yes, and the grant that we have will pay for the time that we're putting to COVID sick.
Okay.
So that's the $1.5 million grant. If for some reason that one gets all taken up, there still is another grant out there, but it's under the normal emergency grant. And we would have to do the 20% as a match for that grant.
Okay.
Right now, we're fully covered by the 1.5 million in what we have today.
Where do we stand on the 1.5 million?
We haven't used all of it. We've
What
got
have we
expenses that can.
Ballpark, just
I'm
ballpark.
sorry. I would say that if we put it all in, we're at about $1 million right
Okay,
now.
all right, good. About two-thirds of
Two-thirds.
it we use.
Yes.
Okay, thank you.
So this would mean that the county would save money if someone's getting paid half a day's pay, staying with the example we've used all this time, the 4 hours, and then 4 hours with COVID pay. That would come out of the grant, that second
Okay.
4 hours.
Yes.
So then the county is saving money by doing it. This is
Sure.
what I want to hear. This is what taxpayers need to know. That's all I'm trying to get to. Okay.
Okay. District Clerk, you want to make a brief comment?
I do have a question. These employees that are working from home, you know, we're using that COVID sick. What about the employees that don't have laptops or have ways to remote and they're upset they cannot remote in and help to do what they need to do at the office? How are you going to do this where it's not discriminatory throughout the whole county, where you're able to work from home but you're not able to work from home? I want to make sure that my employees are treated fairly because I do have people working at home and they're working, and then the other ones that are not working are using COVID
And-
sick because they are literally sick.
Is
Please
it-
let me finish, Commissioner
Okay,
Mosher. So basically, I want to know with this county for what we have in place to make sure those employees are all doing what they can be doing from home in order to be productive employees. Some may have no symptoms that are out, but I don't have the means to provide them with a laptop.
So let me ask you a question. So is the concern of not having, your concern, if I'm interpreting correctly, is they don't have the laptops to be able to do the work from home?
Correct.
Okay, and I think I sent somebody an email on this, is there some way we can get laptops for those types of people that Don's talking about?
Sure.
Whether they're leasing or whatever, and would that not be covered by the COVID fund grant also? Because I think Don's got a really good point. You know, people will be able to work, they just don't have a laptop to work with.
Because what's happening throughout this county, this one's getting to take a laptop home, this one is not.
Right.
They're gonna get paid, but this one has to use all their sick. Well, guess what? They've got kids that have been quarantined. Now,
We're not on the agenda item anymore.
oops,
The
sorry.
agenda item is specifically about the sick leave allotment,
Okay.
and working on the hours, not about providing laptops.
But that's a matter to take up with IT.
It's a matter we need to just
With
take
sick
up.
leave,
but
that's
it's
what I
not-
just wanna know. How are
Just
my
talk to IT
employees
about it.
are going to,
Talk
because
to
right
IT.
now with the sick leave
You
time,
can talk to Bruce right now about
I will take care of that, but, I
Yeah.
think
Yeah.
he's done all he could do for me, so.
Okay.
it. I have a laptop, you can have right now.
Yeah, I know one.
Yeah.
He's got one. We got
But
two
the
right
But,
now.
issue
but
is-
I wanna talk about the sick leave, that's my main thing. I told my employees that are home, so they were all equally, they're all COVID sick, because they are COVID sick right now. So that's
We
how
have
their
maintenance
time got
workers
entered.
that can't work from home. So
There's a lot of people that
If you
can't.
want equality, then there's an issue there. But we can't do that for everybody, because everybody's job is not the same, and as the county attorney pointed out a moment ago, some are more critical than others.
One
Right.
thing I think that needs to be stressed is the COVID sick is an additional sick leave bank compared to whatever their normal sick leave bank already has.
Correct.
So regardless of whether they're home working or they're home COVID sick, they're still getting paid
Right.
for the.
Right, and that's the key
80 hours.
point. That's the
Yeah.
point why it's on here, why we
They're
want to
not using
extend.
up their current sick leave bank. This is an additional 80 hours of paid leave that the county and the federal government have given them because they aren't able to work. So I think they're all getting paid.
And I don't think the pay is the issue. I think it's
But that's the agenda item issue.
COVID, no, the COVID sick is the issue on the pay thing.
Right.
Right. And all employees are getting
We
sick.
weren't aware of some
And
of those things.
to move it on, I'm gonna make a motion that we add an additional 80 hours under the guidelines of the Families First Corona Relief Act, and add additional 80 hours under that act for COVID sick.
Second.
Up to the end of December.
As long as the act is in place, I mean, yes.
Well, that's what
Yeah.
Jennifer said.
Yes, up to the end of December.
Okay.
Everybody understand the motion and the second? I made the motion, Commissioner Baloo made the second.
I have one more question for Jennifer. Just how many people are we talking about right now that have used up, say, 80 hours?
Well, I won't be able to
Ballpark.
determine that until after the end of this pay period, but
I understand.
probably the list of folks that already have run out. We only have one that's currently
Okay.
in quarantine.
So we're not
but-
talking about mass numbers, but we're gonna have a
Right, we
few.
have,
We'll be
Less than 10.
We'll be approaching
More than
10, more like 20 by the end of this pay period. I
Really?
One thing you might
Okay.
clarify is
Okay.
it retroactive or not?
Yes. My intent is that this is
To
retroactive.
when?
This is retroactive for this year, as long as we've been acting under the federal
February.
guidelines.
Since the federal,
Since this act has been in place.
since the act. Okay. So, and the good news is that we haven't had too many people dreadfully sick, but that could happen and then they could use up all of it. One person in the hospital and wreck everything for them for a long time.
Correct.
But thank God we have
Right.
most of the people that have gotten better.
We got a few back this week.
I think that one of, it sounded like one of Dawn's concerns was that what if an employee is out, say now, using the COVID sick leave and comes back, but then down the road their child is sick or they're quarantined again because of a sick child or a sick spouse or whoever in their family may be sick, and then they run out of that time. And I think that it's important for employees to remember, and directors and electeds, that things like this happen sometimes. And if it does, it's a case-by-case basis that we can all come to you as supervisors and talk to you about our particular employee and what those circumstances might need. And y'all have always worked with any of the employees and supervisors in the past when something strange or particular has come up, and it's important for employees to remember that. And I think that that you all want people to be safe when they come to work and know that their county is going to take care of them.
And that could happen to anybody, we understand that.
Any additional discussion? All in favor, raise your right hand, say aye. It's unanimous, we extended it by 80 hours.
Thank you very much.
Thanks, Jennifer.
1.3, consider, discuss, take appropriate action regarding regularly scheduled special commissioners court meetings. Mr. Moser.
Thank you, Jonathan. We implemented we've always had standard meetings second and fourth Monday of each month. And then we've started meeting more often than that because of requirements for authorizing the treasurer and the auditor to pay bills. That has gone away, I believe, and I'll let the county attorney amplify that. I think we're not required to do that anymore.
That's correct. You're not required to do
So my question is, I think we've eroded, okay, the special sessions of Commissioners Court to take up things that are not, they can't wait, they could wait until the regular sessions. So all I'm asking for is for a discussion on whether or not we should try to stay with second and fourth Monday, okay? Or we could keep every single Monday. Because I meant, there's some trivial things that we're doing putting on the agenda on the intermediate Mondays that I think, I guess the bottom line is, I don't like to have meetings if there's not a reason to have a meeting. Okay?
I agree with most of what you said. Occasionally there are some that.
And we can have an emergency meeting and the judge is out there, I think within X number of hours. If we have an emergency, we can have Commissioner's Court. Yeah.
We're not under state of emergency.
Yeah, no, but I'm saying, but independent of that, we can call a session of Commissioner's Court within, 72 hours or something like that. And I think in an emergency, we can even do it more earlier than that. But anyway, that's okay.
That's a different topic. I mean, the bottom line is we don't have to meet every week any longer.
Right.
And so we go back to
Right.
our meeting twice a month as we.
And I'm just saying, let's put things on the regular schedule as opposed to creating a need to have a Commissioner's Court if we don't need to have one. If we need to have one, let's have it.
Last Monday was probably
And that's
a
the
good
judge's
example.
prerogative to call Commissioner's Court.
But that was a rarity.
It was a rarity, but last Monday we had almost nothing. It was not really worth.
Yeah.
That's right. Yeah, we had $25 from the sheriff, and you had an appointment to a board, which wasn't critical. So,
But
thank you to the person
from a
who gave
planning
$25.
standpoint, though, I think we need to go. It's difficult to wait till Thursday to find out if we're gonna have a Monday meeting.
Right.
A lot of us schedule weeks in advance. So
Right.
I think we need to either go, yes, we're gonna meet every Monday, or no, we're gonna meet twice a month, and I'm in favor of twice a month.
me too. And I don't know if it takes a motion or it probably doesn't take any action. We'll just schedule or the judge.
Well, I think it should be stated real clearly that we are not required to have a meeting every Monday. We started having a meeting every Monday because we need to approve payroll and some other things because of the state legislature. And now that has passed. And some counties never took up this every Monday or every week meeting. And so that's over with now. So it's not like we're leaving business undone. We're back to normal now.
Okay.
If we decide on this.
Right.
And the question is, I see the auditor in the wings over here. Daniel, when you come in, because it does have an impact on paying bills. Because they can't pay the bills until we
Right.
approve it.
And
given enough time, we can go back to paying them twice a month, I think without any doubt. And we did it in the past, you know, it does cut down, it may, on the amount of time that we have to prepare if we're getting late bills that we need to pay before we get fined, you know, or late fee or whatever. So there may be some of those, there's always been some of those in the past though. I mean, that's just standard, just because of the way it's gonna happen. The only thing that I would ask is that, I know next week, because of planning, next week we will have to have a meeting. There is a bill that y'all will need, or an invoice y'all will need to approve.
Okay.
And then the week of, the first week in December, I think it's December the 7th, we'll need to meet that day also. And these are for plans moving forward that are already in place right now, that looking forward. Now, after the first of the year, I think there'd be plenty of time, you know, to meet twice a week and let everyone have enough time to ramp up back to realizing it's
So
gonna take 2 weeks.
I think simply then, what I'm hearing is, let's plan on meeting second, fourth Monday of each month, unless there's a reason, like you're talking about right now, to have another meeting. And so you're saying up till, well, period, okay? Unless there's a reason, okay, that it can't be held during the regular session, second or fourth Monday, period.
Yeah. I think, Commissioner, basically what we can do is just leave it up to leave it on our calendars, personal calendars, every Monday for the rest of the year, but let the judge have the discretion to cancel the Monday meetings if there's not sufficient items, and that will allow the auditor. And then the first of the year, when we do one of our early January meetings, we will set the official dates, and we can go over it.
That's fine, that's fine.
So within the judge's discretion till the end of the year.
Yeah, good, okay, great.
There was a court order that was passed that allowed us to pay certain bills without y'all's approval, because y'all gave pre-approval. It was utilities, I believe.
On something, East Curve Water Project maybe.
Yes, for the
There were just a
grant.
couple.
Yes, and so we may need to just look at that and see if there's anything we would like to add to that, but we can do that at a
Okay.
future date.
Good deal. Thank you.
Good.
No action today.
Okay, good deal. Good.
Item 1.4, consider, discuss, take appropriate action on implementation of burn bans. This is our regular 90-day agenda item to continue the process we're currently using.
I move for approval.
Second.
Motion from Commissioner Harris, second Commissioner Moser to continue implementation of the burn ban.
And as the judge, as Sheriff said, and I cited the other case too, it's really important that we have that capability to set those burn bans and to have the sheriff be able to enforce that. Good, thanks.
Any further discussion? All in favor, raise your right hand and say aye. It's unanimous, 4-0. Item 1.5, consider, discuss, and take appropriate action to approve the disposition of a Colt 45 Gold Cup semi-automatic pistol. Sheriff Fairholster.
Okay, this I need to explain a little bit. A couple of y'all I had when I brought it up. My chief deputy since 1990 has been carrying a certain Colt 45 national match pistol. The reason he has been is him, at that time he was with the 216th Judicial District Task Force, and they worked what ended up being one of the largest marijuana cases in Kirk County. My dad was part of it, my chief deputy was part of it. Doing surveillance on that, permission on a surrounding piece of property from the suspect property, they were walking through there and my chief deputy stepped on the pistol. This is just out in the middle of the pasture. Okay? Chief deputy picked it up and asked my dad, "Did you drop your gun?" My dad said, "No, I got mine in my hand." So, you know, it went on kind of like that. But after the case was over, we ran a search warrant on the suspect. The case was filed in federal court. He went to the federal penitentiary over it because, like I said, it was a large marijuana growth, one of the largest around. And Judge Hippel Garcia of federal court awarded that found pistol. When they ran a trace on the gun and everything and doing a search warrant on the suspect's property, in his house they found a list of all his guns by serial number. And that pistol was on there, and it was out beside it, he put lost. Okay, he had been trespassing on his neighbor's property and dropped his gun. That's probably what happened. But anyhow, Judge Hippel Garcia, federal judge at that time, said in a court order that that particular gun by serial number that such weapon be assigned to the district attorney for the 216th Judicial District to a law enforcement officer of said district to be used in the exercise of officer's duties. So my chief deputy, being one of the case officers in that case, has carried that gun ever since. When Bruce Curry, who was the district attorney and over the 216th Judicial District Task Force, when he retired in 2014, I think, when he added, he, of course, first in 1990, he even wrote that he assigned that gun to Clay Barton, my chief deputy. Then in 2014, Bruce Curry retired and he ordered the assignment of that weapon, same one, it's ordered bearing that serial number, to be given to the Kerr County Sheriff Rusty Hillholster to be used in his official duties as sheriff and with the authority to dispose of or reassign said weapon to a law enforcement officer in this district. So I just kept it assigned to Clay since he's carried it all these years. I contacted Heather a while back. The gun, Clay's had to replace the sights on it. You know, it's a 30-year-old gun. Okay, actually, it's older than that.
Sure.
Doing the trace on it was manufactured in the early 80s. But, and Clay's had to do some work on it over the years, replacing sights at different times and everything, and it's more of a sentimental value to him. It was one of the last cases that him and my dad got to work together. Okay, and as y'all know, my dad was the first narcotics agent stationed in this county. So there's a lot of history just going back there, and Clay would like to keep it. Checking with the county attorney on how can we make that happen, what can we do. There is, under the government code and the local government code, it says purchase of a firearm by an honorably retired peace officer. Of course, Clay's retiring the same time I am. You know, December 31st midnight, we're both retired. And that he may purchase one firearm from the county that as an honorably retired officer. The county commissioner's court shall establish the amount which may not exceed the fair market value for which the firearm is to be purchased. So, what I'm asking y'all is to set a value at less than fair market value, because that's what the law says it, and allow Clay to purchase that weapon. Clay's been an employee of this county, doing law enforcement for this county, between the task force when he was there, and then he was assigned to the feds, but he was always Kerr County, did a lot of seizures in federal government, even some up in New York that came back to this county, and I think he's been an extremely valuable law enforcement officer in this county. He's got, right now, right at 39 years, he's got 1 year less of service than
What's fair market value?
If you wanted my opinion, because of the officer it's going to, somebody told me a roll of pennies would be perfect for that officer.
Commissioner,
No, my question, what's fair market value?
well, we get to establish that. I got an idea. Given the
Can I get an
history
answer to my question?
of
Did anybody research it is the real question.
What's fair market value?
Some,
Right.
you know, some of those guns, and I'll be honest, I looked up, if they were in mint condition, okay? Now, I have to preface this.
Sound like a politician. What's
No.
fair market value?
Well, it changes because of the gun and because of the condition of the gun. Okay, it changes
Agreed.
drastically. Some of them made that long ago can be worth up to $4,000 or $5,000.
Okay.
New, I haven't priced a new
But
semi-automatic
this is not new,
45.
so what, in your judgment, okay, it's of some condition, what is fair market value?
I think
Just-
fair market value of that gun, because it had rust on it, he's had to do a lot of work on it, it's had thousands and thousands of rounds fired through it. My personal opinion is maybe $200 would be fair market value.
That's what
Because
I
of
was
the
trying
age
to
and
get
use
to.
of that gun.
That's what I was trying to get to.
Well, let me make a motion. I move that we sell this gun to Clay Barton for $1. Can I get a second on that? And we'd be done with this?
Second.
$1.
We have a motion and a second to sell the gun to Mr. Barton for $1. Any other discussion?
The one I will add is I was at ATF one time doing a case that we filed here, and they had just seized guns from a gun dealer that wasn't operating legally in San Antonio. And they came through that office with a roller cart with, I bet, 100 brand new in the box Colt 45 pistols that they had seized. And I asked them what they do with those, because you know some agencies would love to be able to get their hands. Every one of those go to the shredder. Period. That's what they do with most seized guns. This was an exception that Judge Hippo Garcia assigned it to here. So, and it's not that the county's been out a dime on this gun, ever.
Okay.
All right, we have a motion and a second to let Mr. Barton purchase the gun for $1. Any more discussion? All in favor, raise your right hand. Unanimous, 4-0.
Okay.
Thank you, gentlemen. I'm sure, I know Clay will thank you.
You bet.
Item
In
1.6.
pennies.
In pennies. Has to give the treasurer pennies.
Item 1.6, consider, discuss, take appropriate action to approve the electronic recovery and access to data services agreement with EGI ARED Group Inc. Sheriff.
Okay, what this is the drug dealers, and this is putting out some stuff, they may try and change it because this is a public meeting, but what we found is drug dealers, and they're finding this all over the country, Secret Service, ATF, DEA, all of them, is they're not dealing in cash as much anymore. Right? They have the equipment capable, and we watched this demo on it, and what they're doing is buying green dot cards, or you know, from Walmart or any of these gift cards. You can even do it to a hotel room key. Any card that's got a magnetic strip, they can transfer money to that card. All right? And when they're doing drug deals and that, all they're doing is transferring money from cards to card and then, you know, spending it as they want. But they're not dealing in cash, in your cash seizure. And you may stop a drug dealer that's got a stack of 20 or 30 cards on it.
Is there a limit on the amount?
Nope. No, it can fall, if you can find it all out, it can fall under the Money Laundering Act and everything. There's a lot of laws that pertain to it, but you have to be able to get access to it. And what happens normally when you stop somebody, by the time you get them seized and you know, lock up the cards and evidence, within 30 minutes they'll call somebody and all that money will be off those cards, transferred to other cards. Okay? This is an act that a deal that even federal government, ATF uses it, or Secret Service uses it, and everybody else. What it does is it gives us the capability to swipe those cards right there on the spot and see what's on them. And if it is drug related, if it is a seizable, forfeitable offense, we have the capability of locking that card. So money can't be transferred from it.
That's not an unreasonable search.
No. No, courts have ruled on that. They've already said that that's not, because it's a illegal money laundering. You have to have probable cause to do it.
Sure.
If I just stopped you on a traffic stop, you know, and saw that you had a gift card in your wallet, no, I can't do that. Okay? But if you're dealing drugs and you got 4 or 5 green dot cards on you too and very little cash, that's another deal. Then you start getting up probable cause. And that's what the courts decide. Okay? But yeah, same thing. So what it is for us to do this, it is $3,000 annual fee and then $500 for the readers that we can use. Both DAs sat in on the demonstration and the meeting with us and with the company, and they're totally in agreement with it. Heather has reviewed this agreement. The agreement is actually an agreement I signed, but seeing how this county works, I did not want to be doing anything without the court's approval. The fees would be paid for through our seizure account, so it's not coming out of county money. I'll pay for it out of the seizure account, and then, you know.
Even the $3,000 plus the $500?
Yes.
Okay.
Yeah, I'll pay
Move for approval.
the annual fee.
Well, I want to ask another question. Is this software or is it hardware, or is it both?
Both.
Okay.
Second.
A motion, Commissioner Moser, and a second, Commissioner Harris, to approve the agreement and authorize the sheriff to sign the agreement with EGI ARED Group Inc. Any further discussion? County attorney's review.
Is every car going to be equipped?
No.
They have to call in a number? I don't want you to tell us anything you shouldn't tell us.
No, we will have a number of these that can hook to cell phones that can scan right there, but not every officer's not getting
So
them.
it work like one of
calls.
those squares?
Okay, yeah.
Okay.
Okay.
Should pay for itself.
And, you know, the thing is, Harris County, Houston PD, all have it.
Yeah.
every one of them.
And the key thing is it doesn't cost taxpayers anything, it's an additional benefit.
It's all, the druggies are paying for it themselves.
Yeah, exactly.
Further discussion? All in favor, raise your right hand, say aye. Unanimous, 4-0. 1.7, consider discuss take appropriate action to approve in-code public safety records management services with Tyler Technologies. Sheriff.
Okay, this came up because our lovely federal government and state have decided that they are changing the way that law enforcement has to report crimes. Right now, we have what's called UCR, Uniform Crime Reporting, and it only reports 7 of your major category offenses and all that kind of stuff. Well, all the higher ups in their great wisdom have decided now that that's not what we're going to use anymore. We're going to use what is called NIBRS. NIBRS is National Incident-Based Reporting System. All law enforcement agencies have to start using NIBRS by January 1. Okay? Odyssey, that this county has contracted with for all these years, cannot do NIBRS. We have tried working with them, and even though Odyssey is a Tyler Technology deal, they can't do NIBRS. And NIBRS is a lot more in depth. It gets information such as relationship between victim and suspect, you know, criminal, I mean, it's unreal the number of, and the amount of information that we're now going to be having to send to the feds and the state on crimes in our county. And it's all just for statistics, which I'm totally against, but we don't have a choice. Okay? So, Tyler Technology, who is also part of Odyssey, they do have an N code, same type thing as the timekeeping and everything else. That's a part of Tyler Technology. They do have an N code, which because Odyssey can't do it, they're giving us N code in the law enforcement management for the same exact price that we currently pay for the law enforcement part in Odyssey. So it's not costing us additional money. Okay? It's so much a year, part of it, that Bruce pays and everything for the deal. It does allow us, it will automatically gather that information. It has already been approved by DPS and the feds as being NIBRS compliant. So, you know, we have to report it, the racial profiling goes into it, but it has to change, we have to change our entire law enforcement system.
For data collection.
For offense reporting, for everything. Everything I do as far as the law enforcement part is going to be different. It hurts us in some ways because the county attorney doesn't have immediate access to it anymore like we have in this shared system. A lot of what law enforcement has will not be in Odyssey anymore. It's a separate system.
Attorneys and so on.
They won't have access to it. We have to give them view-only access to some things, but they won't have it in all things. It's the same exact one that Kerrville PD is using right now. And she could tell you how some of that works and has to come over for county offenses and, you know, county court law offenses and that, but it is going to change things. But this is something that we have to have by January 1st. We work, Bruce is in there, Bruce, even John Trollinger, before he was here, tried to work with Odyssey. Everybody's worked with Odyssey to see if we could get it compliant. All the other counties that are using Odyssey we've been working with, and they finally said no, they can't do that.
So bottom line is it doesn't impact the budget.
Does not impact the budget. It does impact how we all do business.
Sure.
What about, Bruce, can you come in? What about accessibility with attorneys and stuff and security?
From what aspect?
From, well, the district attorneys, the defense attorneys, different people have to access
The
information.
in-code law enforcement module is totally separate from our Odyssey law enforcement. So in order for them to have access to whatever they need, they would have to have read-only access to the law enforcement module, or you would have dual entry.
They have to use two different systems.
Okay.
Now, they'll have to log into it from a totally different system. And then the head of the law enforcement agency, me or Larry, whoever next, will have to give them that authority to read only. And it can only be read only.
Okay. So it'd be like going into any other program, you use that program, you back out of it, you go into it with another.
Right.
Exactly.
But it does affect us because, like some things, and it affects sheriff's office where right now Odyssey does my civil, it does warrants, it does everything. Okay, case manager, we can go into it all from Odyssey. Right, we can just pull it up on different, and it's all integrated. The same person's pulled into all those different things. We won't have that capability. It doesn't do civil. She will not, the clerk's office will not be able to see in Odyssey that we served this civil paper. Okay? We'll have to return the civil paper to them and they'll have to enter that it's been served or whatever. It's a totally separate system. We're no longer integrated.
It seems like we're going backwards.
We are.
So, and I don't want to get down in the high weeds here, but when a name comes up, somebody's been arrested or whatever, and they have to check and see if there's a civil suit that goes along with the criminal or vice versa, and they have to check two different systems.
Right.
Okay.
Okay. Now this
Because
system,
required by the state and the federal government.
that's right, we don't have a choice. This system, gradually, once they get it done, most of what's in it will dump into Odyssey as far as the upgrades on jail management, because that's where, the other courts get most things. You get identifiers and new addresses and all that kind of stuff on defendants normally from the jail.
Well, let's say, for example, back to the thing, somebody gets arrested on criminal charges, a civil goes with it. Is there something to flag the prosecutor to know that there's also civil charges or anything?
No, we're just gonna have to,
There's no category for that, so they just see there's a red dot or something? No?
no.
How long is this gonna take to get it set up for each stuff?
We're hoping,
They said that they could do it. Now,
We're not doing it, in other words.
well, it's an
Okay.
integration with
Yeah, it's
Tyler
a-
Technologies.
You've got to,
Yep.
they will start, the new ones, we have to be able to report December's, 1 month into it, which would be December. So hopefully they'll get the basics up and going by December 1st, so the stats will start collecting through the month of December, so our first reporting can be done in January, okay? But then it's gonna take them another 6 months they can take what's in Odyssey now and convert it over so it goes into this, okay? So that we have that. But the future of what's in Odyssey after that conversion will not go into this, okay? We can dump from this to Odyssey, but Odyssey will not go into this. And that's the meetings with Tyler Technology we've had. It's gonna be a learning curve for everybody. It will affect everybody.
Well, I move for approval.
I have a question, Sheriff. Did you say the clerks are gonna have to enter something that y'all normally enter? Is that what
Well,
you said?
a lot of times if we serve a warrant, it shows that it got served in case manager, okay? It's not gonna do that.
So that's an additional duty upon the clerks?
I don't know.
check every name twice is what I was trying to get
Salary
at.
survey.
I'll second.
You know,
Motion, Commissioner Harris, second, Commissioner Moser. Sheriff, the question I have is, you mentioned no cost, but it looks to me like there's a contract cost of $4,560.
that's exactly what we're paying right now for Odyssey law
There's an
enforcement
offset.
here, and that will not come due until next year again, when we normally do. But it's the same amount.
A motion and a second, motion Commissioner Harris, second Commissioner Moser to approve the Inco Public Safety Records Management Services with Tyler Technologies. Any further discussion? All in favor, raise your hand, say aye. Unanimous, 4-0. And it's a little after 10, let's go ahead and take a break. We have some timed items coming up at 10 to come back into session at 4:15. All right, it's 10:15. Call the Commissioners Court session back into order. Item 1.8, receive engineering report from developers engineer for the Meadowbrook Retirement Community Manufactured Housing Rental Community Development Plan, Phase 1, located at State Highway 27 and Hoot Owl Road, Precinct 4. We do have several speakers that would like to speak on this, but first we'll hear from Mr. Hewitt. Good morning, John.
Good morning. My name is John Hewitt. I'm here to speak about Meadowbrook Retirement Community. Since the last submittal, the owner has constructed 2 detention basins on the site to ensure that there's no additional runoff, that the proposed conditions peak flow do not exceed the existing conditions peak flow. He put 1 detention basin on the west side of the property, and his property goes all the way to Johnson Creek on the west side. And so those flows, there's an outfall channel that crosses State Highway 27 and goes along the west side of Phase 1. And he put a detention pond over there to make sure that there's no extra flow. I've got some numbers for you. The existing flow is 871 CFS for a 100-year event. His proposed conditions flows increase that number to 930 CFS. So we built a new detention pond in there that's about 4 feet deep. It has a storage volume of 50,411 cubic feet, a 24-inch drain pipe that comes out of there, and after the flow is routed through the detention pond, his proposed conditions flow is 868 CFS. So there's a decrease from existing conditions associated with that. So he spent money, built that detention pond, and that has ensured that the flows for the proposed conditions are less than existing conditions. He's got rock riprap on the outside of that pond to make sure that the flows are not excessive coming out of there. I think they're about 6 or 7 CFS or feet per second coming out of there, and so there's no scour coming out of that rock riprap. That again, there's no private property between his property and the Johnson Creek property on the west side.
Okay.
In addition, on the east side of his property, he took out one of his lots and put in a detention pond on the east side also. The existing conditions flow on that side was 29.9 CFS. After he put in the roads and the additional impervious cover, that increased to 58 CFS. After he put in the detention pond, that number went down to 27 CFS. So again, the proposed conditions are less than the existing conditions on the east side. That particular basin is 4 feet deep with a storage volume of 26,981 cubic feet. Again, there's a 24-inch discharge pipe that drains that basin, and that discharges onto a rock riprap area to slow down the velocities to ensure that there's no erosion coming out of that pond. In both basins, we provided a safety factor, and in detention ponds, that's called freeboard. So in both cases, we have at least a half a foot in the ponds just as a safety factor. So the numbers show that there is no increase in flow coming out of either pond, and there is a little safety factor in both ponds.
So John, so those were for 100-year events?
And that's correct.
So now and I'll ask you a question, maybe you know the answer, maybe you don't. So for the freeboard that you have, what would be an equivalent increase in the probability? Would it go from, just taking up the freeboard, would it go from a 100-year event to a 200-year event or a 175-year event?
Yeah, we didn't do those calculations, but
you could do that. That'd be interesting.
Yeah,
it's good what you've done. And is 100-year the criteria? And Charlie's out there. 100-year the criteria by with which you do that, or you do
5, 10, and 100 per county criteria.
What's that?
5-year, 10-year, and 100-year.
So, well, which so 100 years the maximum.
100-year set the size of the ponds, but
Okay.
I have numbers for the 5 and the 10 as well.
But that's okay. So 100-year is what's been done in other places in the county. So this is consistent with the criteria used in the county other places?
Correct.
Okay, and in addition to that, you still have freeboard?
Yes.
Okay, good. Fantastic, good report.
That was good.
Question, you mentioned are these detention structures are accounting for all of the water that will be coming off this development?
Yes. All the water's routed east or west through these ponds.
Wow.
Are they complete yet, or?
Almost complete.
Almost, okay, all right.
Good.
Because I know some of the smaller rains we've had, I mean, there was too many complaints.
Yeah, they
Under
were not
construction.
complete at that point,
Yeah,
that's correct.
exactly.
Okay.
Good.
So this will not change what has been, what people expect to get there will remain the same pretty much.
Correct.
Very good. Thank you, John.
We have 3 individuals that have signed up to speak on this item. First, Aubrey Henderson.
They might be upstairs, Rusty.
Yeah,
Aubrey. Hey,
they might be
Charlie,
upstairs.
why don't you get John to come around there too with you in case there's a question?
Remember, this is a non-action item.
Right.
I know, but it's just
I know.
for discussion.
When I saw you out there earlier, I thought you were the sheriff, the new sheriff.
Sheriff?
The sheriff-elect.
You want it? You have it.
No, I don't want it. I don't want it. I'm too old. I think Larry has the same shirt on today.
Cripple. Good morning, guys.
Give them a
Good morning,
sense of your name.
gentlemen.
and
Can I hand something out, Jonathan?
Sure.
Or he can, I think I made enough, because I made enough. Each one. You might have an extra one, I'm not sure.
Thank you.
Aubrey, were you able to hear what?
A little bit, but that's okay. I'm not here to yes or no or anything else. Is these pictures, was there an extra one or not? Wasn't one?
Yes, this one. Who needs one?
Yeah, give it to, is it David up there? Well, he can follow me too if he wants to, or he can look at John's, whatever. These are pictures that are taken from the south side of the property from Ms. Havens, where the water's gonna end up going. And what he was just saying, the engineer that was just here, I guess that's who it was, it said all the water has been routed to these ponds, is that right? Isn't that what he said a while ago?
Yes.
John? Yeah, I think it is.
Yes.
Yes, it's all the water off the property goes.
Okay, go back to the picture, and I won't be long. No, Highway 27, where it says 5 by 7. There's what I was talking about before, where the 5,000 acres is going to drain from Rocky Ford's Ranch. 2,500 is going to go to Henderson Branch, end up in Johnson Creek a different way. 2,500, 3,000 is coming through that hole right there. I know, we talked about it before, that's been over the road. That water is going that direction where these ponds are going to go. Okay, look at what we've done on the ponds. We hadn't concreted them or nothing. Look at where they're at the fence line. They have put the dirt. There's no way they've moved off of their 8 to 10 foot. Jonathan, you know from experience that if we don't pack that dirt, Ingram Dam, when it flooded, it washed out the spillway. This is going to wash out all that dirt. It's kind of like putting a Band-Aid on something. Where all that white rock is, that is an 18-inch, or Mr. Hewitt can say a 24-inch culvert, whatever it is there. That's supposed to supply the water, the overflow. So what you have done, guys, you've turned the water all on Ms. Havens. I'm not here to say right or wrong, but what you've done is you've turned all the water that used to go the other direction. It used to go between field A and field B. There was 200 feet that went direct to Johnson Creek. You've turned all this water to these ponds. Now we're trying to catch all of it, then why did we put this culvert in it? When it overflows, it's going to go on Ms. Havens, her pecan bottom and her grass bottom. If that water gets up, it's going to cut a ditch in between there and 110 feet of Johnson Creek. All this stuff that we're catching, oil, everything is going to go in that pond. Harley, is that right? Would you go along with that?
Sure.
Everything, good or bad or anything is going to be in that pond.
For a 100-year run.
5, 7, whatever it is.
He said it was designed for 100 years.
I know, I heard that, yes. But if we have a flood, Tom, if we have a flood across this, I told you before, and I'm going to tell you one more time, if we have a rain, we're just going to say 5 to 7, but if we have a tropical storm, and I told you, forget Johnson Creek on this property, Completely forget it. I told you where your problem's gonna lie, is gonna be from the other side of Highway 27 coming through this culvert, and it's been over Highway 27 because it rained too much. We all know that the Texas Hill Country has rocks. If we get a 15 or 20 inch rain on the north mill of the Rocky Ford branch over there across the road, half of it from Interstate 10 goes the other direction. Everything on Interstate 10 comes this direction. Half of it goes to Henderson Branch, a different valley. The other part comes to here. It all comes right here. So what I am saying is, it doesn't have to be a tropical storm to get this property flooded, and it doesn't take a rocket scientist to figure that this pond will fill up. Why did we put a culvert in? Because it is going to get up that high. Look at the pictures. It's going to get up, so it's going to overflow. Is that right?
I have a question for you, just
Yeah.
a reference.
I'm sorry, go ahead.
The question is, where,
That's Highway 27, John.
where is this culvert in relation to this picture?
Comes straight through. Highway 20, that's the one in your right hand, that's Highway 27.
Right, it's under 27.
Okay, that's Highway 27 in between the entrance of the property and the other side. It's a valley that comes all the way through the property. But what we did before is we channeled that. The man that had it before had planted coastal, and he had between the field A and field B, he had it channeled and fixed right where it would go straight to Johnson Creek. No problems. We remember when Tom, I told you about the terraces? There was 5 terraces in that field. We all know what they were. What was that to do? We knew that the water would come that way, and it would slow down. We'd see water for 2 or 3 days. It'd be all in those terraces, and then it would soak in the ground. It was designed that way. When we cultivated, we planted fields. Jonathan knows that from agriculture. We know that. But now we wiped all those terraces out. We changed the flow. So here we are, right here. We're right up against Ms. Herring's fence right here. High fence, and that water's going to overflow, and it's going to go straight to Johnson Creek.
Okay.
But what's happened is, I mean, I would have thought, you know, that they would have concreted it. Because this is not going to hold. This will not hold.
You don't want it to stay there. You want it to soak in.
No, but I'm saying the dirt, Harley. I'm saying the dirt tank itself. I don't know if he can ask me, did they seal it? Maybe they put bentonite in and they sealed the bottom of it. But the bottom line is, this thing will fill up. We know that water, if we get a lot of rain, it will fill these ponds up that quick. We're going to have overflow. So all that's going to go to Johnson Creek. But we got we have dirt with some rocks around the culvert on both sides.
Let me just listen to what John's calculations say.
Right, Tom.
That pond will hold water for a 100-year event.
Well, I disagree on that.
Well, but I'm just saying, I'm just
I know,
saying.
I understand. I'm listening.
That's
I'm
what John
listening.
said. So that's what his analysis says,
Correct.
okay? That's what this says it to. So can we hear from John on that, to address that? I mean, it sounds like your experience is inconsistent with what John's analysis is.
Right.
Okay? Yeah.
You want me to come over there or from here?
Yeah.
They're gonna be
Over
here.
here.
Yeah. Step off the side for a minute.
Yeah. All right.
So I agree with the gentleman that there's a lot of flow that comes through State Highway 27, that channel. So much flow that we didn't route any of that through the pond because we could not contain that much water. So we kept that flow coming through there separate from our pond, and we over-detained on the area that's coming through our site, through the pond, and left that area separate. So he's right, we couldn't route all that water through our pond, it would blow that pond out.
Right, okay.
So that's a good point, and there's a lot of water that comes through there, and we kept it separate from our pond.
Where's
it going?
In its own channel, goes straight to Johnson Creek, not through our pond.
Oh, I see.
So it's an off-site channel that continues through the site, but does not go through the pond.
Okay.
The pond takes the runoff from the site, over-detains that to compensate for any other impervious cover on the site.
So if
that's
the site-
18-inch
the site
culvert.
the site wasn't there, that's the way that flow would go.
And we kept
outside
that
the
flow
site.
going through there
Okay,
because
yeah.
it's impossible, or it would be very costly to take all that water that's running across State Highway 27, and he's right, that's a lot of water through there. We could not have run that through our pond, so it's not going through there. So
Now, is your pond gonna have anything to seal it? That was-
no, we want that
You
water
don't want
soaked
to.
in, yeah.
Well,
Yeah.
it was brought up, so we'll get it up. Okay, here's what I think it's gonna flood no matter what, because that's the hill country. It's gonna flood no matter what. Retention pond, no retention pond, it's gonna flood. And we're gonna see
Based on no
different years,
analysis,
there's gonna be
Harley.
different floods. Sir?
So you do not believe the analysis?
I believe the analysis is accurate to a point, and I
It's
believe that
accurate for
Mr.
100 years.
Henderson's experience is accurate to a point, but we always have those floods that surprise us, and regardless of how much you plan for it. We all know, if you're on your way home and this low water crossing is already starting to flood, you ain't gonna make it all the way to the house. We all know that stuff. You know how to measure it. We all know that.
Right.
You've seen it for years. You get to a certain low water crossing, it's already coming across there, you might as well go back and stay at the Y tonight.
Yeah, and the safety factor of this project is if it does come down, like, and I've told you this before, those people are cut off. I want that to go on record, that if that water does come 5 or 7 feet underneath the channel on Highway 27, and it comes there, which I have seen numerous times, it has been over Highway 27. That is a fact.
Yeah.
That much water, it's cut off, you cannot get through there. But those people will be cut off because you will not be able to get them from Johnson Creek to go around and get them because the creek will be up, right, Harley?
Yes.
And you will not be able to go down off of Highway 27 to get to them because the ravine that's coming from Highway 27, which is the Rocky Ford Ranch, will have you cut off. I want that to be on record because that is another factor. If that's the case, then you need to build a bridge down there for the people to get, the old people to get out. It's pretty simple, you know. But I'm gonna leave you with this. I know Rusty's been here a long time. A lot of us been here a long time. You can do anything on your property probably that you want to in Kirk County. We're real lax. Maybe we need to revisit some of that later on to find out. But you cannot all of a sudden put this pond right next to the fence and turn the water. Because if the pond gets so far up, and he's right, but it will have overflow. So why did we put the culvert in? So you have turned the water on to Miss Haven. You have redirected it. Nobody wants to come home. Rusty at Bear Creek doesn't want to come home, and his neighbor built a pond and put a culvert in, and it's right next to his fence, 6 inches from the fence. Nobody wants to come home and go, his wife, your wife, or anybody else, what have they done, honey? And that's what I'm going to leave you with, gentlemen. Be careful because it's opening yourself up to lawsuits. I'm not part of it, but I'm just telling you. The ladies that are going to come here in a minute, they have the property next to it. I do not. But you cannot turn the water, Jonathan, and you know that, onto somebody else for benefit.
Question I have is then to go to Mr. Hewitt. Did you change the flow of the water off the property? Yeah, can you come in and maybe have you walk back and forth? Did you change the direction of the flow?
The exit, where it leaves the
And the
property.
exit point.
So there's two, the off-site channel is going through just like it always has. The one that goes under State Highway 27. And the other thing to point out is that 5x7 culvert maybe can carry a 10 or 25 year storm. It can't carry a 100-year storm across State Highway 27 as it is today, regardless of if there was any development downstream of that. The other question is, did we change the water direction? No, we did not. It goes off Chris Mundall's property. It goes onto his property straight into Johnson Creek.
I mean, the property on the culvert,
Out of that pond.
goes to the fence.
Yeah, this is like looking down a gun barrel from the other side, the fence.
No, but the question is, does you still leave the development where it leaves where it's leaving the development before
Is
the
where it's
construction
leaving
is
today.
still the same? That was your question, was it not?
Yeah. Same-
The idea of
same
mitigation is to not make things worse, to keep them the same, not to redirect
Yeah,
or
but there was-
anything else. It's just to keep problems from happening to your
But
neighbors.
he's saying they're leaving at the same place they were
Right.
before.
Right.
Okay.
That's correct.
So this would be the same, right
Yeah,
there,
that's right.
where it flow anyway.
All right,
Thank you, John.
thank you, Robert.
Thank you.
You bet.
I don't think you can do enough. It's gonna flood. Everything's gonna flood.
Sure.
Next we have Glenna, is it Haven?
Glenna's not gonna speak. She said she wasn't gonna speak today.
Okay. You're Ms. Ellsworth, correct? Then Melanie Ellsworth.
Okay.
Ms. Tanley.
Kind of the same,
And can you give your name and address, please, Ms. Ellsworth?
Melanie Ellsworth, 230 Dowling Road in Ingram. I mean, I think we've I've listened to the conversation, and I think if you have a big and it's gonna, if you have a big flat piece of property and you have this rain that's on this property and it comes off at the same rate, what he's done is it's the same rate, but we've channeled it into a culvert, right? It's the same rate overall, but it's gonna all come out through one hole. Does that make sense?
Mm-hmm.
So,
Is it just one?
yes.
For each retention pond.
Well, when John Hewitt was up here, he said the west side and the east side, he purposely made a point to say the west side, the property goes to Johnson Creek and there's no private property between the development and Johnson Creek. When he talked about the second pond, which is the east side, there is property between Johnson Creek and the development. You understand that? So we've got two ponds. So we're talking about the east pond. It's going to go in a pond and it's going to all channel and have a culvert that's going to dump onto Glenhaven's property. Now, if we have a big flat piece of paper and you dump water on it, that water's all going to run off the paper. It's going to spread out. But if we take a pond and build a pond and then put a culvert, all that water is not going to disperse evenly. Now it's all going in one place. Does that make sense?
Yeah.
So that's the concern. And I didn't have time. It was too cold. I thought about it last minute to go in the river and get down and dig up the quart jar of caliche that's there from the last runoff. I usually get in. You can walk down. It's usually a rock bottom. Now there's about a 12-inch sludge for a pretty good distance because from the last problem we had, which hasn't been cleaned up. This will happen again. It won't be caliche after the building, but it possibly might be the bottom of this retention pond that dirt will come through the culvert and go down. So on paper it looks great, and the numbers say we had this number and now we have this number, and the number's not changed, but we funneled it all in one place. And I'm with Aubrey. It's between Glenhaven and the development, but at some point it doesn't make sense if your neighbor built a pond and put all the water coming out and dumped it on, because what will happen to Glenna's property is it will make a new
erode.
Yes. Yeah.
So let me ask John a question. John, in the old, before the development, the water was leaving at so many cubic feet per second. But it was at a low velocity because it was spread out. That's
exactly.
What you're saying. Okay.
Exactly.
Now it's leaving at the same flow rate, so many cubic feet per second, but it's through an orifice which is higher velocity than it was before. What is the criteria for the velocity leaving one property going to another? Is there a criteria for that?
Maybe we should ask the county engineer that.
Well, I'm asking an engineer. He's designed it.
6 to 8 feet per second.
Huh?
6 to 8 feet per second
Was
is the criteria for storm drainage flow.
Okay, so you can list hypothetically, you can go from 1 foot per second if it's what it was before, spread out, and now you've changed you keep the same flow rate, okay, so many cubic feet per second, but you've driven it through an orifice, so now you can increase it to 6 to 8 feet per second?
Yes, sir.
Is that what you're saying? Okay.
And what was the number that he predicted that it would come out on a flood?
7 feet per second.
So,
right in between.
So, but you're right. It's higher velocity than it was before,
Okay.
but it's meeting some criteria. That's the reason I asked the question.
I'm-
What's the criteria
Right.
that they have to adhere to? And it's between 6 and 8 feet per second.
Okay.
And
We try to put large riprap to slow it down when it comes out of that 7 feet per second before it gets off site to even slow it down further.
So is this fence is at the edge of the site?
Close.
Because that riprap doesn't have a lot of ripping to wrap.
Or I think on a really big one, I think all that rock's gonna be on Glenna's property, but I could be wrong. So I'm just here to raise the question. Earlier, you said you're your eyes and ears on the ground. That's what I am. I'm just trying to bring it to your attention that it might be right, it might not. I mean, maybe it will. I'm concerned that if tomorrow, if we got a really big rain, we got a 1-inch rain and had all that caliche in the thing. If we have a 1-inch rain tomorrow, all that mud that's in the bottom of that pond right now will be in Johnson Creek.
But that's gonna be temporary because the work's just been done.
Right.
Over time, that'll wash away.
Right, but, I mean,
Not much fun in the interim.
In the interim.
well, I'm just saying, long-term, I'm just questioning to make sure it's right. And, I mean, if the numbers are right, the numbers are right. I'm here to just go on record and say, I'm concerned that this might not be legal. I don't know, maybe it is. That's for another day.
I have one other question for John, if I may. On where the flow comes out of the pond to the east, that's what this is, right here, okay? Where it comes out of the culvert, or the drain pipe, there's no riprap between that and the fence, which I assume is the edge of the property. Is that correct?
Yeah, but they're not finished. I mean, this is a work in progress. There will be more riprap between the outlet and the fence.
Okay.
To slow it down.
What's
What's
the distance between the outlet and the fence?
15 feet, I'd have to go check and see.
Something like that.
Yeah,
Okay.
there will be more riprap, and I would
Okay.
point out that the developer wants to be a good neighbor, and if there's an issue, he'll go take care of it. He's done everything he's been asked to do at this point.
Okay.
So there will be more rock riprap.
I guess the question I have, the debris is going to be coming through that culvert. I mean, it's a native grass, sticks, whatever. It's going to blow that fence out.
Yeah.
I mean, that's my experience when I'm looking at that picture.
What
What accommodation, or will the developer make accommodation to prevent that from happening by putting, there's lots of different kind of water gaps, things of that nature to mitigate that. It still may, I mean, in a big flood, who knows what happens, but that current situation, to me, that fence isn't gonna stay that long.
Yeah. Well, he's here. You might want to have him come speak directly to that.
That's good point.
Now,
I fixed
are
all
you,
of it,
are you saying in this,
Yes.
in this picture, John, there's 15 feet between the fence and back here to the culvert? Shouldn't look like it.
I know, it's not. That culvert, the edge of the.
Looks like it's right up on it.
Yeah, it is right up on it.
Does look like it.
It is right up on it. I didn't go, no, the culvert is literally, the bottom slant of the culvert is, I'd say, a foot to the fence. The fence. I
And
mean,
this is whose property on this side?
this is Glenna Haven's.
Glenna Haven's property on this side.
Right.
I don't think that can be 15 feet.
And, no.
Really?
Well,
I mean,
let's have Mr. Mundall speak to that.
Okay, see here.
I mean, if this went up on if this was your neighbor,
Like I said, it's like you're looking down a gun barrel. Right
yeah,
there.
yeah.
Close.
I mean, the breach in the silt fence was the issue because basically we had all the water and now we've pretty much replaced the breach in the silt fence with the culvert. And you put a lawn chair and some twigs in there and then it's, you got a lot, the fence comes out. But
Thank you,
anyway.
Ms. Ellsworth.
Okay,
Thank
thank
you.
you.
I agree with Jonathan. I think this is gonna be filled up with debris and there's gonna be flooding on the opposite side. And then they're gonna need a water.
The question that's kind of come up is on Mrs. Haven's side, or Haven, they say? On her side, how far is the culvert out of the detention pond from the fence? And can anything be done to keep that fence from being blown out in any kind of, well, as soon as that detention pond gets full?
Can you identify yourself for the court report?
I'm sorry.
Sure. I'm Chris Mundall, and I'm with Ingram Oaks in the Meadowbrook subdivision that we're talking about, or retirement community. Yeah, the original construction, that was gonna be a lot there, and we were gonna have those spread out velocities or flows across that area. And then when we had to switch to a zero impact, now we had to create a detention pond, and now, you know, standard engineering is to have that culvert pipe in there. We can do something, I was listening to the story, and we could probably take that pipe and move it back into the detention pond and then broaden it out and run it through you know, a series of riprap to just really slow that velocity down. Because we honestly don't want any damage to the neighbors. And the fence right there, we might be able to put in a piece of the fence. It's our deer fence that's there.
Okay.
And we'll repair it all the time, but we could put one of those blowout bottom pieces that rotates. And, yeah, and go back and fix it every time. At the other property, we have severe rain events and so forth, and we have to fix. That's just part of our repairs and maintenance. And
I think their biggest concern, and I'd say, you know, they have those pecan trees right there, the other side, and end up with a new gully or whatever through the middle of those, you know.
Yeah,
pecan trees.
we would have liked it the first original design. Just we had some pretty strong rain, and we had the silt fence up, and it made the pond appearance, and it looked horrible. But that's not the way it's going to be at the end. And we wish we could have kept the first one. We spent a lot of money, and we lost a month of construction, re-engineering and reshaping everything. But if you look at our projects, we'll take care of that. We don't just build it, forget about it, and let people tear it up. We own it and possess that, and we maintain it and enforce all the restrictions and so forth. So it'd be a highly restricted retirement community, and
so what you're saying is you move the culvert exit further away from the fence, so you reshape the dam part of the retention pond. Okay, so it flows, it has more room to decrease the velocity by running over baffles, essentially.
True.
Before it gets to the neighbor.
It'd be a riprap. I mean,
Right.
the white riprap looks pretty good
Yeah.
versus just a flat piece of
So
concrete.
I call them
or
baffles,
something.
but that's what they are.
Right.
Yeah.
Okay.
And,
Yeah.
yeah, I'd be glad to do that. And we've already done everything we've needed to do or been requested of, and we're not at the end of it. I mean, we're willing to work with everybody. And that sediment that she's talking about is up at the north end, at the west end of the Johnson Creek too. It's all the way upstream. So that sediment comes in there, you have a nice gully washer, it flushes it out, and then it starts to build up. That foot of it or whatever, I'd have to argue that, but everybody knows that didn't.
Okay. That's the question.
Thank you.
Mr. Murtaugh.
Thank you.
All right, that's just receiving the information, no action on that item. Move on to item 1.9, consider, discuss, take appropriate action for the court to approve an amended plat of following water lots 108, 109, volume 7, pages 75 to 76, precinct 3. Mr. Hastings?
Thank you, sir. The well site was shown incorrectly on the original plat, and this amending plat corrects that error. County engineer requests the court approve an amending plat of following water lots 108 and 109, volume 7, page 75 through 76, precinct 3.
I move we approve the amending plat as presented.
I'll second that.
Second by myself, motion by myself and second from Commissioner Blue. Any further discussion? All in favor, raise your hand, say aye. Unanimous, 4-0. 110, consider, discuss, take appropriate action for the court to set a public hearing for 10 a.m. on December 14th for revision of plat of Verde Park Estates, sections 3, lot 2, volume 6, page 93, precinct 2.
This proposal subdivides Verde Park Estate, Section 3, Lot 2. It's currently 6.47 acres into 2 lots. Lot 2A will be 1.46 acres, and Lot 2B will be 5.01 acres. Property access and road frontage to both lots will be on Trimper Trail. County engineer requests the court set a public hearing for 10 a.m. on December the 14th, 2020 for a revision of plat for Verde Park Estate, Section 3, Lot 2, Volume 6, page 93, Precinct 2.
So moved.
Second.
Motion from Commissioner Moser, second Commissioner Harris, to set a public hearing for Verde Park Estates, Section 3, Lot 2, line 6 to 893, for 10 a.m. on December 14th. Any further discussion?
I have a question about access. You said they're both going to access from the same road?
Yes, sir. Off the trunk.
Is there,
Yes, sir.
is there enough?
Yes, yes, sir, they have enough space on both of them.
Are they
And this
in
lot
here?
wraps all the way around. I believe they've already got one.
So it's going to be here, and that's
Probably
enough
here.
for that road and that speed?
Yes, sir,
Okay.
yes, it is.
It's 50 feet.
They've got more than 150 foot of frontage total per row, both lots.
Well, I said 50, I meant 90 feet.
But this is just to set a public hearing.
Yeah, I know, but we asked the question.
All in favor, raise your hand. Approved, 4-0 unanimous. Item 111, public hearing for revision of plat Elm Pass Ranch number 2, tract 36A, line 6, page 248. We'll open the public hearing.
Nobody out here.
There. Record shows there's no one here for that public hearing. We'll move on to item 1.12, consider discuss take appropriate action for the court to accept Crooked Creek Path, 0.69 miles long for county maintenance out of Crooked Creek State Subdivision, file 18-07961, precinct 4.
Thank you. Record drawings prepared by Hewitt Engineering were received on October the 17th, 2018 for the construction of Crooked Creek Path, 0.69 miles long, out of the Crooked Creek Estate subdivision. The plat was subsequently filed on December the 10th, 2018. That's file number 18-07961, and a one-year maintenance bond was secured. Before the expiration of the maintenance bond, a final walkthrough was conducted on November the 1st, 2019, with deficiencies noted: sweeping of loose gravel, cleaning of silt and drainage ditches, and installation of object markers for the road culvert in front of lots 12, 17, and 18. All deficiencies were promptly addressed. However, the object markers were substandard, i.e. they were glued down instead of driven into the subgrade. The said substandard object markers were replaced with standard object markers on October the 30th, 2020. Hence, the road, traffic signs, and associated drainage is in compliance with the approved construction plans. The county engineer recommends that the court accept Crooked Creek Path, 0.69 miles long, for county maintenance out of the Crooked Creek Estate subdivision, file number 18-07961, precinct 4.
I move for approval.
Second.
Motion from Commissioner Harris, second Commissioner Moser to accept Crooked Creek Path, 0.69 miles long for county maintenance out of the Crooked Creek Estate subdivision, file 18-07961. Any further discussion? All in favor, raise your hand. It's unanimous, 4-0.
Thank you.
Item 1.13, consider discuss take appropriate action to set a public hearing regarding the installation of no parking sign on the far northwest portion of Ace Ranch Road East, precinct 2.
Morning. Ms. Sarah Meza contacted the Road and Bridge office around October 5th, 2020 regarding a parked and closed utility trailer across from her driveway. The owner of this trailer actually lives on Cedar Way, one street over. This trailer has made it very difficult to get in and out of her driveway. They have also had to call EMS to come, and this trailer has made it very difficult to navigate through to their address. The right-of-way easement is 20 foot, which is the biggest problem. Found on the plat and plat records, volume 4, pages 105 and 106 for Guadalupe Heights, number 5, dated February 19th, 1978. I have enclosed copies of this portion of the plat for Ace Ranch Road. The front portion off of State Highway 27 is a 20-foot dedicated right-of-way up to Gary Cross Way, and from Gary Cross Way to the back of Ace Ranch Road is a prescriptive easement that is also 20 foot wide. both having an 18-foot wide pavement, so it leaves about a foot on either side of the actual pavement. Since this back portion has no driveways or homes directly across the street, like the front portion, I think installing no parking signs only on this side of the road and on the back portion that has a prescriptive easement will be of great benefit to the property owners on Ace Ranch Road. After Gary Crossway to the end. The proposed no parking signs would only be on one side of the road on Ace Ranch Road East. The house's side, which is the front portion, or actually the back portion, would not have no parking signs. So you just would have it on that one side that has no houses on it, just that back portion. The county engineer has looked at this and agrees that the no parking signs will help this issue. At this time, I ask the Commissioners Court to set a public hearing for Monday, December 14th, 2020 at 10 a.m. regarding the installation of no parking signs on the far northwest portion of Ace Ranch Road East, and this is in Precinct 2.
So moved.
Second.
Motion from Commissioner Moses, second Commissioner Baloo, to set a public hearing regarding installation of no parking signs on the far northwest portion of Ace Ranch Road East, Precinct 2. 10, is it 10 a.m. on?
Yes, sir.
10 a.m. on the 14th?
Yes.
And public hearing for 10 a.m. on the 14th of December. Any further discussion? All in favor, raise your right hand. Unanimous, 4-0.
Thanks, Kelly. Good
Thank
job.
you. Mhm. Yes, sir.
Item 1.14, consider discuss appropriate action for the Commissioners Court approval regarding general contract, small project with Secor Fence and Building Company for a commercial grade chain link double gate, precinct 1, 2, 3, and 4. Ms. Hopper.
Before you are the proposal, Exhibit A with Secor Fence and Building Company for one commercial grade chain link double gate installation in the amount of $1,935. Their certificate of liability insurance, the Form 1295, and the general contract, small project contract that was drawn up by the county attorney with the project not to exceed $2,000. This double gate is to be our heavy truck and heavy equipment access to the property. We store our wood chips from brush cutting. The location for this gate is at our main office. It's the property directly next to it, and then after that becomes the credit union. We store wood chips there, and it'll be a lot easier to be able to access through there. And we worked with Charlie because there is drainage that comes through on that property, and Charlie has approved this location for us to be able to access in there.
You can access it closer to Highway 27 also, right?
Yes, we do have one, but it's got a dip in it that makes it difficult. And I don't know if Charlie wanted to, Charlie had looked at it as far as drainage and flood.
I'm just wondering, so you need a second gate.
We need a second gate because the other one that's closer to the highway, also in a storm event, it's submerged. So this still allows us to get in and out up on higher ground.
I see, okay.
Yes, sir.
So moved.
Second.
Motion, Commissioner Moser, second Commissioner Harris, to approve the contract with Secor Fence Building Company in the amount of
$935.
And
And
county attorney has reviewed?
Yes, I
Yes.
prepared it.
It's in the budget?
Yes, yes, sir.
Kelly, this is gonna be a setting post and everything for
Yes, sir.
new hole in the fence and everything.
Right.
That's a decent price.
It is.
Good price.
All right, any further discussion? All in favor, raise your right hand. Unanimous, 4-0. Item 115, consider discussing appropriate action to go out for annual bids for road-based cold mix, aggregate, emulsion oil, and corrugated metal pipe.
This is what we do every year around this time. We are asking the court to give authorization for us to go out for our annual bids on road-based cold mix, aggregate, emulsion oil, and corrugated metal pipe. Once we put out the bids, we will come back to the court to open the bids on December 14th, 2020 at 10:05 a.m. and also award the bids in court at that time.
What are you gonna do when they eliminate oil?
I don't know.
I move for approval.
You're gonna do it with wind.
No, I want my question answered before.
Well, good luck.
I hope I'm retired by then.
Wonder if anybody's ever thought about that.
No.
How can you use wind-generated electricity to replace the oil on the road?
We have a motion.
Oops, oops.
Do we have a second?
Second.
Second. Motion by Commissioner Harris, second Commissioner Moser. To go out for annual bids for road-based cold mix, aggregate emulsion oil, and corrugated pipe. And for the record, for the attachments, there'll be a notice published on November 12th and November 19th in the Cripple Daily Times.
Yes, we have set that up.
And then bids will be due back on the 10th at the county clerk's office, and then bids will be open on the 14th at the Commissioners Court meeting.
Please go through the checklist on
Yes, we have.
bids.
That's what I went through, that's why I set those
Yeah, right.
dates.
Good, thank you.
Well, Vicki puts this together in our office, and she always puts a calendar in there to show when those notices are going in the paper, so there's no gray on it.
I think the sheriff had a good recommendation. I'll have a standard checklist on all bids.
Yeah.
Right.
Any further discussion? All in favor, raise your right hand. It's unanimous.
Thank you.
Thank you, Kelly.
Who should I give the contract that needs the
Libby.
judge's signature and yours? Okay.
Judge, he's here, he'll sign it.
Okay.
He'll sign it. Item 1.16, consider discuss take appropriate action on Kirk County Courthouse COVID status update. I guess we can go with the general update. I'm looking at the county attorney. General update, and if we need to go into, there's an executive session item related to this as well, I believe.
If we're gonna talk about specific personnel, we should go into executive session, but I think the Jennifer's able to give you a general update without having to go in.
Okay. And there is a second item that will require executive session, I believe,
Yes.
somewhat related. All right.
Okay, well, I will need some guidance as to what to share, what's for executive, what's
I don't
not.
think we should go into specific departments or certainly the employees that have contracted.
Right, overall numbers?
Just
Sure.
overall numbers in the county.
Okay.
I think that's appropriate.
All right. Okay, well, as of this morning, what I've been made aware of is we have 12 positives, 11 in the courthouse, 1 off-site. We had a total of 32 affected. 30 people were quarantined, but that's including the positives and the people that have been exposed. We have 4 that have returned from quarantine, and we have another 3 that are self-monitoring. They both feel their exposure was limited. So that's where we are as of today.
I
And
think it's important for the public to be aware that we have been following throughout this outbreak last week, the CDC guidelines. And the nature of the people that have tested positive, they have not had contact with the public other than through a screen or something of that nature, so they've been protected according to CDC guidelines, as I understand it.
Right. And I know Commissioner Mosier was asking for statistics last week, and we have about 107 people in the courthouse, and 11 out of 107 is 10.28%
Wow.
positive rate. So.
That's high.
Right. So Friday, I received a call from Jaime Lopez, and he's with the Department of State Health Services, Region 8 in San Antonio. I think I've shared that email with all of you. He had been made aware of a positive case, and they have to investigate. Apparently, he could not tell me a name or the department, and I asked him, and I said, we have more than one, so why are you only questioning this one? He said a lot of people don't give their employer's name, but in this instance they did. And when they investigated, they found that the individual said that somebody had come to work feeling ill, but came anyway, exposed this person, and they were positive, and they said they also exposed several others in the department. And he wanted to make sure mainly that the employer had been made aware, because a lot of employees test positive, they want to keep coming to work, they don't tell their employer. I assured him, yes, we have been made aware. He wanted to make sure that we were taking all the precautions. social distancing, masks, additional cleaning, heavy cleaning, deep cleaning during the day and after hours. And everything else, you know, the markers 6 feet apart, and behind partitions where we can. And I told him that we have been, but the main thing that he shared a lot of information with us, and the main thing that's going to be very helpful to me, and is one of the handouts that he gave, is COVID-19 quarantine versus isolation. And it says basically, the DSHS could not make recommendations, but their recommendation was to follow the CDC. And the CDC's guidelines is that if you've had close contact with a person who has COVID, you stay home until 14 days after the last contact. Check your temperature twice a day, watch for symptoms, and stay away from people who are at high risk. Now, that's quarantine. Isolation, if you are sick and think or know you have COVID, then you stay home at least 10 days since the symptoms first appeared, and at least 24 hours with no fever, without fever-reducing medication, and symptoms have improved. If you have tested positive for COVID-19 but do not have any symptoms, stay home until 10 days after 10 days have passed since your positive test. And he just, Mr. Lopez just stressed that a lot of people think it's allergies, feel a little drainage, scratchy throat, they think that's all it is. But if they're saying if that's what you have, then stay home. The other thing, since we do have, they do consider 2 or more cases an outbreak. And I'm required to give them information, name, dates of birth, addresses, and phone numbers of everyone affected in quarantine, so they can do A-line contact tracing type testing. So I'll be providing him with that information this week.
2 or more cases for what?
For an employer.
But if an employer has...
And he didn't say that, he just said for us, 2+ cases is considered an outbreak.
For this county?
For this.
For our numbers, I guess.
Yeah, for the county employees.
For county employees? Okay.
Correct.
Okay, all right. I have a question on CDC.
Alrighty.
And the deep cleaning.
Okay.
What does CDC say about deep cleaning requirements in light of how long coronavirus can last on a surface?
You know, for everything that he provided that I read, there was no mention of that.
Could
it
you
was
see if
clean
you
all
could-
surfaces.
My question, are we doing a lot of extra cleaning we don't need to do, or spending money we don't need to do? If the virus only can live on a surface for, at one time it was 3 hours, right, Harlan?
Yes.
So if it's 3 hours and it's gonna sit overnight, we don't need to go in and deep clean everything.
Well, and a lot of this conversation has to do with the department. I'd rather talk about that in executive session, but so, but I really do think that we need heavy cleaning.
Well, but you can think that.
No, I mean, the CDC recommends that. During the day.
That's my question. What's the
additional-
CDC, wait, let me ask my question. What does the CDC recommend?
They just say deep cleaning every night after hours, and then additional cleaning throughout the day.
Okay, so that's CDC's recommendation.
Yes.
Okay, you
They
answered my
don't
question.
really define what deep cleaning
Yeah.
involves, just says deep cleaning.
Okay, you answered my question. That's
And they
their
haven't
recommendation.
changed how long the virus
Okay.
stays alive on the surface, from
That-
3 hours to anything else, so it
There's
kind of
no-
is a moot point anyway.
Yeah, so that's their recommendation. You answered my question. Thank you.
I think that the main takeaway that I have is that, and a number of emails went out late last week from the HR director, that if employees are having any kind of a symptom, and we had, and I believe she listed in her email, I think everybody on the court got a copy of it, but it's fever, sore throat, runny nose, headaches, any of those symptoms, call your supervisor before you come to work. And the supervisors should be, help make that determination. And that's why we had a long discussion this morning about, it is authorizing an additional 80 hours of COVID sick to be time for these employees to keep them out of the courthouse if they're sick until we can be sure that they do not have COVID.
Well, all of those symptoms you just mentioned, I can understand, but another symptoms, aches and pains, and probably all of us would stay home.
Yeah, it's difficult, but,
Yeah.
and some of us, we're in allergy season for a lot of people that have ragweed and all that, but,
Most of us know the difference. You can tell the difference if you feel like you have the flu or you feel like you have stuffy nose or something.
Well, DSHS, the symptoms that they list, I will read them. Fever, cough, difficulty breathing, muscle aches, tiredness, sore throat, headache, runny nose, chills, stomach pain, nausea, vomiting, or diarrhea. And I've also read other places, loss of taste or smell. So, yeah.
Just for the record, I've been doing this morning. I've been doing that for 15 years, so there's no change. So it's not a runny nose
the problem comes in.
This changed.
The problem comes down is that asking our employees to err on the side of caution right now until we get
Right.
down a little bit, because of that list, I know several people that had none of the symptoms and had COVID. So that's where the problem comes.
Right.
You know, I had a headache it was a severe bad headache for half a day, and others have had certainly not the flu-like symptoms.
And I've talked with several that tested positive that said the same thing. All they really experienced was a headache for part of one day.
So, the employees just need to be as cautious, and this is also for the public to know that we're taking appropriate measures per CDC guidelines to protect the public. And that's why the item's on the agenda.
Okay.
Good. I don't think there's any action on that item. We do have 2 executive session items that's not related to COVID. The first is through our approval agenda. The auditor of the bills were handed out during the meeting. Michelle? Okay.
Yes. Invoices for today's approval include $3,452.86 for Kerr County, $600 for the airport, and that is for last fiscal year. For the current fiscal year, $65,990.51 for Kerr County, $47,857.98 for the airport. Adult probation, $6,181.78. County clerk fees, $109.65. And the DA forfeiture, $241.95.
Move for approval to pay the bills as presented by the auditor.
Second.
Motion Commissioner Moser, second Commissioner Blue to pay the bills, treasurer and or treasurer disbursements as presented. Any further discussion? All in favor, raise your right hand. It's unanimous, 4-0. Budget amendments,
There are not any.
late bills,
Yes, we have a total of $1,818. The majority of these are hog and coyote loans. Hogtails and coyote loans.
I move for approval.
Second.
Commissioner Harris and the motion, Commissioner Blue made a second to approve the late bill as presented. Any further discussion? All in favor, say aye. Raise your hand. It's unanimous. Auditor reports,
There are not any.
monthly reports.
Yeah, we got quite a few. For October 2020, standard monthly report from Constable Precinct 1, Tommy Rodriguez, Constable Precinct 2, Kyle Snyder, Constable Precinct 4, Gene Huffaker. Fines, judgments, and juries fees collected, JP1, Mitzi French, JP2, J.R. Hone, JP3, Kathy Mitchell, County Clerk, Jackie J.D. Dowdy. Payroll approval report, month ending October 2020, County Treasurer Tracy Sullivan. And then for October, we need to read all these?
No, that's just the county.
That's just part of it?
Correct.
Okay. I move for approval.
Second, motion to accept the monthly reports. Motion made by Commissioner Harris, second by myself. Any further discussion? All in favor, say aye. Raise your hand, say aye. Unanimous. Court orders, we have our court orders from our November 2nd meeting. Court orders 38418 through 38422. They all look to be in order. I make a motion to approve.
Second.
And a second by Commissioner Harris. Any further discussion? All in favor, raise your right hand. It's unanimous. Status support from department heads. Don't see any. Status report from elected officials? None. Status report from liaison commissioners? Mr. Blue, do you have anything?
From what? From
Liaison.
Liaison, no. No, not really.
Mr. Moser?
Nope.
I don't have anything. Okay. Then we will go into closed session under 4.2 personnel matters per section 551.074. We have two items that are listed. One is consider discuss take appropriate action to discuss personnel issue, Don Lance, and another one is consider discuss take appropriate action regarding COVID situation with county personnel, put on by myself. That second one, we may or may not need to actually have any discussion on. Okay. But we need to speak on individual employees. All right.
About 5-minute break.
5-minute break. We'll come back in the closed session and let It's 11:53 and we're back in open session. I'll make a quick motion. I don't know if it's necessarily, but I'll make a motion that we request the HR director and county attorney to work on 3 emails to go out under the judge's email that will address 1, CDC guidelines, 2, the new COVID-19 expanded policy that we adopted earlier today, and explanation of the modified HIPAA regulations during the COVID outbreak.
Second.
Motion second. Any further discussion?
What item number was that on?
42B.
42B.
Thank you.
All in favor, raise your hand. It's unanimous.